All right, here we go. Now again, this is what Bachata Intimate wrote. Did you get permission from Kevin Samuels to show his clip? All right, now we're going to answer that question later in the broadcast. All right, we're still going to answer his question. And then he says from lawyer to business owner, right? Meaning that Bachata Intimate must be a lawyer. To the business owners, which is Rodney and I here at the Power of Offense. We own the Power of Offense, right? Fair use is not always as it seems. So this is advice or guidance that Bachata Intimate is giving us. Fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use. Now, again, let me stage this. Now, Bachata Intimate wrote this because Bachata Intimate listened to a video that we published that we were analyzing the claims and allegations being made by Jessica, aka Miss Average at Best, against Kevin Samuels, the popular YouTuber and image consultant. All right. So what we were doing, we were analyzing the claims and allegations being made, and we took a look at the video of question, the infamous video where Kevin Samuels was giving advice to Jessica, aka Miss Average at Best. Right? So we did use Kevin's video. We used his video because we had to view the video and discuss the interaction within the video to see if the claims and allegations, right, by Jessica, aka Miss Average at Best, was legitimate. Now she's making a claim, right, that Kevin Samuels violated her privacy. That was the claim. So we wanted to watch the video to see whether we could determine that what she is saying, in fact, really happened. Anything you want to plug in on that, Rodney?
None, not really, because once, and based on what we saw in the video, we made comments.
Yes. Commentary, comments.
Yeah, exactly.
Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view.
Right, from an informed, intelligent people.
Yes, people that understand that ignorance of the law is no excuse. We're going to I was going to say, not at all. So we're going to go to the law right now. We're going to go to this case law. All right, we're going to see what the federal Supreme Court, the United States Supreme Court, has to say about fair use. That's what we're going to do, because again, we appreciate the concern from Bachata Intimate. Bachata Intimate, we appreciate your concern. Yes, we do. However, right, we get our guidance directly from the source, which will be the federal Supreme Court. All right. Here we go. The case that we're going to look at is Campbell versus Akoff Rose Music, and this is from 1994. Now, we're not going to read the entire case, but what I did find interesting when I was reading through it is that this case dealt with 2 Live Crew. Now, people in our generation, Rodney, I'm at the very tail end of Generation X. Very right. Tail end, like the last year, So I kind of shared Generation X and the millennial generation, you know what I mean? Right. But I remember 2 Live Crew from when I was a youngin',
Yeah.
And they were dealing with, I didn't highlight the song, but this case is dealing with their commercial parody of the song "Oh Pretty Woman." I thought that was interesting. It reminded me of the movie "Oh Pretty Woman Walking Down the Street." That movie is good, but it's unrealistic. Hey, Roddy, that movie got these women thinking they could go out there and be a prostitute and pull a high value man. Really?
That only works in Hollywood.
You know what I'm saying? But it was a good movie. Don't get me wrong. I did enjoy the movie. Pretty Woman, But yeah, all right, let's get to it. So we're going to scroll past some of it, and we only want to deal with the part that's dealing with fair use.
Go back up to the to the beginning. I mean, right where we started.
Okay.
I thought I saw something. I had to put my glasses on. Yeah, right there. It said that this is the question. The question is, We are called upon to decide whether Two Live Crew commercial parody of "Oh Pretty Woman" may be a fair use within the meaning of Copyright Act of 1976. So that's the question. That's one of the questions that they're attempting to resolve. What's going on with fair use? And I want Keith to break it down by and through this case law.
Yes. Fair use. All right. So Rodney just laid it out there what this case is dealing with, y'all. He just read to you the preamble of the case, which gives us the entire scope of what we're going to discuss. Now, I'm gonna start at number 2 right here, because number 2 goes directly into fair use. It says, it is uncontested here that Two Live Crew's song would be an infringement of a Cuff Rose's rights in "Oh Pretty Woman" under the Copyright Act of 1976, 17 USC section 106. And then it says, but for a finding of fair use through parody. Now, I want to throw this out there. Normally, we do read through footnotes. Normally, we read the footnotes, and you should always read the footnotes, everyone. But in this case,
number 4, right? Yeah.
But
let them know what that number. Yeah.
That number 4 is a footnote, and we do encourage you to read the footnotes. Now, in this case, we're not going to read the footnotes because I already read them. You know, it's going to take unnecessary time, and we don't need the footnotes to build on what we're saying. So we're going straight through. All right. But we definitely want to throw that out there. Normally, you should read the footnotes. Yeah, that's a good practice.
Yeah.
So right here, it says, now we have 575 right here. I highlighted. It says, from the infancy of copyright protection, some opportunity of fair use of copyrighted materials has been thought necessary to fulfill copyright's very purpose, and that is to promote the progress of science and useful arts. Now, this is from the Constitution, the United States Constitution, Article 1, Section 8, Clause 8. I thought that was interesting right there, Rodney.
Yeah.
I didn't know that initially. You know what I mean? I actually learned that from reading this.
Right.
You know,
useful arts and science, all that falls under copyright. So it makes sense, but I didn't understand that either. And then so that makes sense.
Yep. Now it says, for as Justice Story explained. All right. Now a lot of what you're going to see through here is the federal Supreme Court quoting Justice Story. Now, Justice Story is out of Massachusetts, so I figured Justice Story must have been a very bright justice.
Yeah.
You know, but right here it says, for as Justice Story explained, in quotes, in truth, in literature, in science, and in art, there are and can be few, if any, things which in an abstract sense are strictly new and original throughout. Every book in literature, science, and art borrows. It must necessarily borrow and use much which was well known and used before. And that was quoted from Emerson versus Davies. And again, that's out of the Massachusetts circuit, and that's from 1845. So yes, the court does use old case law, just like we used from 1833 when we read to everyone that ignorance of the law is no excuse. That's still good case law. You know, you have some awesome case law from the 1800s, y'all. You really do.
Those are really
the foundation.
Some of the best case law, because it was before, in my opinion, what I call legal corruption now. Within you find case law today, and there's a maxim that protects using old case law that says, and I'm paraphrasing, you remember that it says the older the older the case, the better, something like that. Whatever the oldest is truest.
Right,
remember that maxim, something like that.
Yeah.
So when you go back to these old case laws, that's in the true sense of law, because and the one right below it, 1803, that's less than 40 years from when the founding thieves did the Declaration of Independence and Constitution. So that's in the truest sense of the Constitution and the Declaration of Independence, these old case laws. And then after that, it is what it is. Go ahead.
That is facts. That is facts right there, y'all. Please take note to what Rodney just dropped on you. That was a golden nugget. Now, the court goes on and says, similarly, Lord Ellenborough expressed the inherent sorry about that. Let me just start over. It says, similarly, Lord Ellenborough expressed the inherent tension and the needs simultaneously to protect copyrighted material and to allow others to build upon it when he wrote, in quotes, while I shall think myself bound to secure every man in the enjoyment of his copyright, one must not put manticles upon science. Now, manticles would mean, it basically means restraints, right? So no one should put restraints upon science. Now, this was cited from a case out of, or should I say from a court out of England. Now, for those who don't know, that American jurisprudence actually follows the English common law. Now, there are some differences, but a lot of American jurisprudence is based in the English common law.
And just another side note, English common law, if you're from the state of Maryland and you read Maryland Constitution, which encompasses the Declaration of Rights, because the United States is the Bill of Rights, so Maryland's Declaration of Rights. Maryland Declaration of Rights actually says that we can use English common law in the state of Maryland.
Yep.
So that supports what Keith said, and it's constitutional. Yep. If you're in the state of Maryland.
Yes, it is.
And if you know how to use the Constitution, you can use it in any state.
Facts.
But that's another story.
Facts. And you know what, Rodney? I think one day we should cover the Maryland Constitution just so people can see that.
Yeah.
You know what I'm saying? But yeah, the English common law is protected in Maryland. You could actually use the English common law.
The Magna Carta, all that, you can bring it up. Right to travel. It's a whole lot in there.
You're right. Now, the court goes on and says, and I highlighted right here at the top, it says, in copyright cases brought under the Statute of Anne of 1710. So copyrights existed way back then, y'all. It says English courts held that in some instances, fair abridgments will be what we call fair use, right? Would not infringe an author's rights. And then it goes on right here, and it says, and although the first Congress enacted our initial copyright statute, Act of May 31st, 1790, 1 Stat 124, without any explicit reference to fair use, as it later came to be known, the doctrine was recognized by the American courts nonetheless. All right. So the court goes on and says this, and let me scroll down some. All right, right here. It says in Folsom versus Marsh, and again, this case is from 1841, Justice Story distilled the essence of law and methodology from earlier cases. In quotes, he said, look to the nature and objects of the selections made, the quantity and the value of the materials used, and the degree in which the use may prejudice the sales or diminish the profits or supersede the objects of the original work. Thus expressed, fair use remained exclusively judge-made doctrine until the passage of the 1976 Copyright Act, in which Justice Story's summary is discernible. All right. So the passage of the 1976 Copyrights Act, right, was predicated upon the brilliant work of Justice Story in Massachusetts. Now, I think that's pretty awesome, man. That's beautiful to go on the resume.
That's right.